Subimal Bhattacharjee, cyber law, cyberspace analyst expert. How do I introduce you? Sanjay Pinto, advocate of the Madras High Court, media law expert, former journalist. Shivam Vij, well-known journalist and blogger. Sudhir Tailang, celebrated cartoonist. My first question is to Ramachandra Murthy, S Ravi's lawyer, and I hope S Ravi is going to be joining us in a couple of minutes as well. Now, is it true? Is it true that your client, Mr. Murthy, is it true that Ravi was dragged out of bed at 5 o'clock in the morning by CBCID men and told that he was under arrest? Is that how it unfolded?
Yes. Actually, what has happened was, some policemen, they didn't even show that they were policemen. They knocked the door of Ravi and they thwarted him. They took him to, without even saying where they were taking him away. I think for about 2 or 3 hours, their relatives and wife of the Ravi, they don't know where Ravi was. And later on, they ascertained that they are in CID police. Then we came to know. Then they approached me and we went to the police station, and we came to know that the so and so facts has happened. Actually, you know, you are well aware.
You believe the young Mr. Chidambaram? You think that Mr. Karti Chidambaram is backed by the law?
Not backed by the lawyer, being only influential. This has been done because he has not even lodged a complaint in person. Actually, what he has done is he has sent a fax to Inspector IG of Police Pondicherry, wherein the IG of Police forwarded the fax message to the CBCID police station. What the CBCID has done is immediately they registered FIR based on the fax message.
What do you think?
Could be done.
Okay, what do you think, Sanjay? Sanjay, you think this is an attempt to harass and intimidate? That's all? This is not an application of the law. This is the use of political clout to harass and intimidate.
Arnab, first I'd like to reiterate that I'm not Karti Chidambaram's lawyer and I'm not representing him. I would also like to start by making a distinction between free and hate speech, between well-founded criticism and unsubstantiated reckless allegations, between dissent and abuse. Having said this, Arnab, I personally believe, as an independent, from an academic standpoint, from a legal perspective, that this particular tweet was an unsubstantiated allegation. If Karti Chidambaram felt annoyed, and that was a term even used in Section 66A of the IT Act. It's not, the Information Technology Act was not written by Karti Chidambaram. It's a law as it stands. He has a right to seek legal recourse. He has a right. It's one of the legal options.
No, but 66A, 66A, Sanjay, and I want to take the 66A, I want to take that to Subimal also. 66A says that you can get 3 years in jail for posting online anything that is, and I quote, any information that is grossly offensive or has menacing character. This man has 16 followers on Twitter. He has 16 followers on Twitter.
That's the wording of the law.
No, he has 16 followers on Twitter. Subimal, is that something that is menacing character? A man who has 16 followers on Twitter makes an observation on the integrity of the finance minister's son. Now, is that a...
Or no, you've made only the
Yes.
You are making only reference to the first part of 66A. If you see, it would more be applicable provisions that, you know, possibly the police would have picked up. And I would first like to clarify that it's, you know, it's the police interpretation and not Mr. Chidambaram's pronouncement to the police, you know, that this is what you should do. From 66A2, there are different categories of content that is being listed out, including intimidating and something like that. But there is a very specific word written persistently. Now, if you see Mr. Karti's defense, he's saying that in the last 1 year, this gentleman has sent 3 such tweets. And the last tweet was something, you know, it's a kind of allegation that, you know, it depends. It's a very
no. So by that logic, all the people
interpret.
No, by that logic, you see, law works on the basis of precedence and on being equally applied to all. By that logic, should it be said that let us today find out a list of all the people who might have posted tweets on Robert Vadra, and if anybody posted more than 1 tweet, then it can be said the person is a serial offender and should be picked up at 5 o'clock in the morning by the respective CBCID teams in all the states and let us put them in lockup. Because that's precedent.
And that's, you know, that's where, no, I don't think that's a precedent, but, you know, there are no precedences also of 66A to that extent that, once it was amended in the year 2008 and put into practice, this kind of interpretations have become very subjective depending upon
Let's get the other side.
Police interpretation.
No, my point is that can you use a section of the law to simply curb possible dissent? In a democracy, is there space for any form of dissent? That is all. Sudhir Tailang, I'm bringing you into the debate tonight. You've heard the argument made by both the cyberspace expert as well as the esteemed lawyer from Chennai. Your rebut to them.
See, Arnab, I personally think that this is a completely bogus and draconian law which must be done away with. In the next winter session, I appeal to all the opposition parties and the government that please come together and repeal this law, remove this law completely, because this is a completely bogus law. And this is time and again being misused by politicians, officials and everybody who has some power to intimidate people who do not have any. It began with Mamata Banerjee's, you remember Mamata Banerjee arrested this cartoonist professor in Calcutta.
Yes.
He simply emailed a cartoon which was not even offensive. Now, this is a very vague law. You can interpret anything according to your own convenience. Like Mamata Banerjee's government interpreted that cartoon to their own advantage and arrested the cartoonist.
Welcoming.
I think high time. This is 21st century India. This is a democracy. We have a section 19 also given by the Constitution. We have freedom of speech also.
This is
and
everyone's.
Hair split each thing in this legal language and arrest each and everybody. See, there are hundreds of thousands of people on the Twitter.
Let's get a response.
Everybody is writing every day something about the government, about powerful people.
Once, Sanjay, I'm going to come to you. Sanjay, I'm going to come to you. I want to go to Shivam Vij. I want to welcome Ravi. Ravi, who is joining us right now on the debate tonight. He is the person who is being accused by P Chidambaram. Shivam Vij, you're hearing the argument tonight. You're very much into, tweeting. Would you also now be cautious about which political person or which individual you tweet what about?
No, in fact, I will be less cautious, because if I have to bring attention to my cause, all I have to do is say something about the politician and hope that he will charge you with 66A. I will go to jail and the world will get to know about my accusations even more. So from the point of view of just spreading that tweet, Mr. P Chidambaram has actually hurt his own case. This is called the Streisand effect, where you actually bring more attention to what you're trying to censor. In other words, I think it's very foolish to charge persons with these cases. But I want to address what Sanjay Pinto said. He said that Mr. P Chidambaram did not write section 66A. That is true, but his father's government did write it, and it wrote it precisely for the purpose of political dissent. This is part for curbing political dissent. This is part of a long series of examples where draconian IT laws are being used to control what people say on the internet about the government, especially on the issue of corruption. Remember that Ravi Srinivasan, as he will tell you himself, is a volunteer of the India Against Corruption movement. Asim Trivedi, also charged with 66A, was with India Against Corruption. There is, if you look at Google transparency reports, state and central governments have been asking Google to remove stuff from the internet which criticizes the government, and Google has refused to remove it.
Ravi, you are facing two charges from our panelists tonight. First of all, welcome. Please don't think this is an inquisition. I'm not putting you into a dock, and I have no powers to wake you up at 5 o'clock in the morning and arrest you. My point tonight to you is different. Two individuals on our program are making 2 points.
With you, Mr. Ravi.
One sec. I just want to.
We are completely with you, Mr. Ravi.
No, one sec. I will come to you. Ravi, are you a serial offender vis-a-vis Mr. Chidambaram? As in, the law says, one of our panelists says that the law says that if you are repeatedly doing this, if you are persistently, the word is persistently, making use of a computer resource or a communication device to cause annoyance, inconvenience, danger, obstruction, insult, injury, criminal intimidation, etc. Have you been persistently harassing P Chidambaram? That's the point being made.
Arnab, I'm a small-time tweeter. I started tweeting only on 23/3/2011 and I only tweeted 107 times, out of which on P Chidambaram I only tweeted once on 1910. 1910-2012. The other tweet which Mr. Chidambaram, Kartik Chidambaram is referring was done on 19/12/2011.
Yes.
So only 3 tweets. I am not a regular tweeter, and whenever I feel like I have to express something, I just tweet.
Wrong.
And I had only 16 followers.
16 followers.
And out of them 5 are my relatives.